Welcome back to Family Life with Mama Rita. Just last week, I can't believe it, just last week was October. Hey, a month has come already. We are in November. And because last week was October, we did breast cancer awareness. And I want to say a very big thank you to Dr. Betty and Dr. Ba. You did such a fantastic work. Oh my God. The people who sent me messages, there was one message I received. The lady said her sister got breast cancer in January. And since January, she hasn't been able to touch her own breasts to try if there was anything in. Why? Because she was scared after hearing her sister's report. But after Wednesday, she had so much hope that we have survival cases. I mean, people are living after breast cancer. And now they can do breast for you. You won't have, oh my God. I enjoyed it myself last week. And since last week, I've been trying my own breast. And I'm ready to go and do a mammogram to check, but I know I'm free. Thank you, Dr. Ba, and thank you, Dr. Betty. Remember I told you we're putting a halt on the divorce. I told you I was going to come to the studio with Lawyer Vivian. Please, all the questions, all the legal questions, she will answer them today for us. But before then, hey, I have a sponsor, Lyndon Gates. They are into properties and construction. They are also into selling land. And they have locations in Afienya, in Shy Hills, Pram, Community 25 Extension, Dodowa, Oyibi, Chopoli, my own area, and Dowenya. Please, if you want a land to buy, and this is a service land, they can register your land for you. They can build for you if you want. Please, everything will be on the screen. Take their numbers, write their numbers down, and please call them for a land. Don't wait till you are 60, or you are 59 and a half, or 59 3/4. When you know you are about to retire, and then you are ready to get a land and put up a house. My darling, you don't need to get the bulk money. I hear when you have small, they will get. Small, they will get. Small, they will get until you finish paying. And then you start it just a little at a time. I did that to City of Shiloh. I started paying and paying and paying and building small. Now, I have accommodation for about 3,000 people. My darling, start now. Guess who is in the studio today? Oh my God. I can't wait myself. I'm so excited. People have been waiting for her. Hey, please, I need to do the sign of the cross. To have gotten this woman here today, please, start thanking God for me. In the studio with me today is Lawyer Vivian. Lawyer Vivian, you are welcome.
Thank you, Mama Rita.
Hey, people can't wait for you. They can't wait. I was in America. People were asking me, when am I bringing you on? I think people have questions to ask. welcome.
Thank you.
And then welcome everybody. We want to draw the curtain on divorce. So if you have any legal questions, please ask them today. Lawyer Vivian, I want to find out, what are the grounds for divorce?
Well, under our law, there's only one ground. Only one ground. And that ground is that the marriage has broken down beyond reconciliation.
Okay.
But in proving that one ground, the law says there are 6 facts that a person can use to determine or to ground that sole ground for divorce. I'd go into that later, but I'll just mention the 6 facts in a minute. The first fact is adultery.
Adultery?
Yeah.
Hey, my God. The men, please, I hope you are listening. And these days, it's not only the men.
It is not only the
Some
men.
of the women are also doing it. Hey.
So adultery, we have adultery, then we have unreasonable behavior.
Okay.
And then we have desertion. And then we have the circumstances where parties have not lived together as husband and wife for 2 years.
So what's the difference between the 2 years and the 5 years?
The 5 years, the 2 years is with the consent of the party against whom the divorce is being filed. The 5 years is just 5 years simpliciter. You don't need the consent of any of the parties. So once the parties have not lived together as husband and wife for 5 years, the law recognizes that as enough proof that this marriage has broken down beyond reconciliation. And then the sixth fact is that the parties have differences that they can't reconcile, and so they can go their separate ways. But there's only one ground for the dissolution.
When you say unreasonable behavior, what exactly do you mean?
So these are behaviors that affect the other party. So that there's a couple. You have, it's not so much the quality of the behavior, but the impact of the behavior on the person complaining of it. So it is not a question of, you are being unreasonable, or that the behavior is common or is normal, and so you should be able to tolerate the behavior. It is more the impact. So if somebody might say that if you give me a slap, it is nothing. You know how they say sometimes people think that your spouse must beat you in order to show you love.
Hey.
But for some people, it is nothing. But for others, it is a big thing. Yes. For some people, and you know that there are several forms of abuse. Sometimes it's psychological, sometimes it's verbal, sometimes it's economic. And all of those things can be behavior which affects the other person adversely. And for that reason, that form part of what we call the unreasonable behaviors. You
answered this question last week, but it looks like even after you left, it kept coming. Can a customary marriage be dissolved in court? People don't believe it. People don't understand it. People don't know how it can happen. And it keeps coming week after week. Does it happen?
It does. Ordinarily, we have the Matrimonial Causes Act, which is the act that takes care of divorces. Ordinarily, it is only in respect of marriages that have been contracted under Part 3 of the Marriages Act. In other words, only monogamous marriages. But the law makes provision for people who are not necessarily married under Part 3 of the Marriages Act, but the other types of marriages that are recognized under the law. So customary law marriages or Mohammedan law marriages, where parties to this type of marriages want to dissolve their marriage, they can still come to the court. And the court would apply not only the provisions of the Matrimonial Causes Act to dissolve their marriage, but also look at their personal law. In other words, if they are, for example, if they are GAs, the court would also look to see what are the grounds for divorce in the GA system. And they will look at that, and they will add the provisions of the Matrimonial Causes Act to determine the dissolution of the marriage.
Okay. So, assuming one party wants divorce, the other spouse says, no, I don't want divorce, what happens?
It doesn't lie with the other party at all. You can't say that the other party wants divorce and you don't want divorce, and therefore you want to remain married. There's no court in this land, in fact, I dare say no court in the world that can say two people must necessarily remain married when one party doesn't want to. Like we say, it takes two to tango. If one party doesn't want to remain married, you can't force the party to stay in the marriage. You can't. There's nothing you can do about it. And once that party goes to court and is able to establish the facts to support that sole ground that the marriage has broken down beyond reconciliation, the court will go ahead under the right circumstances and grant the dissolution of the marriage.
Wow. Can a court ever refuse to grant divorce?
Yes. A court can. In fact, under the law, even though the law gives us 6 facts to demonstrate that a marriage has broken down beyond reconciliation, the court still has a discretion not to grant the dissolution of the marriage.
Wow.
A court has a discretion not to grant, not a discretion to grant, but a discretion not to grant the dissolution of the marriage. If it thinks that even though the parties have demonstrated that, you know, maybe 1 or 2 of the facts that have been listed in the law have been established, it thinks that maybe giving them, the parties, you know, the right opportunity, they may be able to reconcile their differences, and so might decide that, you know, even though you have established, I think that the marriage has not broken down beyond reconciliation. Maybe it has broken down, but not beyond reconciliation.
Wow.
And so the courts would allow the parties to explore reconciliatory settlement of the issues.
Why do you have to go to the court by all means for a divorce?
You necessarily must. It's only a court of competent jurisdiction that can dissolve a marriage that have been contracted under Part 3 of the Marriages Act. If you were married under customary law marriage, you can use the customary procedure to dissolve it. You don't necessarily have to go to court. Like I said, I explained the last time, parties to customary law marriages are now resorting to the court because they find that the principles of fairness and equity in the distribution of properties that have been acquired during the marriage seems to be better exercised at the court than the customary panel. So you find that parties to such marriages are also resorting or going to the court. But if you are married under Part 3 of the Marriages Act, it is only a court that can declare your marriage dissolved. It is only a court. It is not
so
separation.
Family members can't come together and say. So it means that when you are married under Part 3, there's nothing like, oh, we got married, so I'm taking the drink.
No.
You know, some people are married under Part 3 and they still take drinks.
It is absolutely unnecessary. In fact, the customary law marriage, after, you know, usually people would contract the customary law marriages and then convert it into a marriage under Part 3.
That's right.
And so people have the impression that once you have gone through that kind of procedure, then if you want to divorce, you must also do the customary divorce and then go to court again. It is not the case. Once you do the proper conversion of your customary law marriage to a marriage under Part 3, that customary law marriage ceases to exist. And so you don't need to take any customary steps to dissolve it. You don't need to go and see anybody to dissolve it. What is in existence is the Part 3 marriage, is the monogamous marriage. And that one, it is only a court of competent jurisdiction that can dissolve it. And you know, usually some parties to decide that the parties, the marriage, maybe the parties have lived apart for a very long time. And so they think that with the effluxion of time, the marriage is dissolved. It doesn't dissolve like that. It is a court that can pronounce on the status of the marriage after you have brought the necessary evidence before.
What's the difference between divorce and annulment? I hear annulment, I hear divorce. Is it the same thing or there's a big difference?
Well, I can say for a fact that all of them end in the termination of the marriage. But there are particular procedure for annulment. In fact, we call it nullity proceedings. And it is in respect of void marriages or marriages that are voidable. I would explain. Now we
You
say
saw
a
my
marriage.
face.
I know.
I just wanted to tell you.
I don't want to use
I
too
didn't
many.
go to the law school.
I don't want
with
to
you.
use too many legal jargons. But a void marriage is like a marriage which never existed.
Okay.
So, say for example, if you are already married to somebody else, and then you go and attempt to, or you go and marry another party or another person under Part 3 of the Marriages Act. First of all, you don't have the capacity to do that. Let me explain again. If you are married already, it means that if you are married under Part 3, it means that you can't contract a second marriage. If you attempt to do that, that second marriage is void.
Okay.
It's void from the beginning.
Okay.
It has no legal consequences.
Okay.
It's void. It has no legal consequences whatsoever. But a voidable marriage is a marriage which is considered valid for all intents and purposes unless one of the parties to that marriage takes steps to have it set aside. So maybe there's some defect in the marriage, but it doesn't go to the root of the marriage. I'll give you an example. So maybe a party to a voidable marriage discovers after the celebration of the marriage that the spouse is carrying another person's baby.
Baby, okay.
It's a voidable marriage.
Okay.
It is not void.
Okay.
Now, the other party can decide that, oh, it's nothing. I mean, I can live with it. And so they will continue the marriage. It's a valid marriage to all intents and purposes. It is only when the other party discovers it and decides that, no, I do not intend to continue. Then he takes steps to avoid the marriage, to set it aside. But otherwise, it is good for all intents and purposes. So you have a void marriage, which is void from the beginning. It's like it never existed. And then voidable. And those are the circumstances, those two circumstances are those circumstances under which you can actually go for nullity proceedings. You can go and annul the marriage because you discovered after the celebration of the marriage that your spouse is pregnant by another. Okay. Or that your spouse is maybe your cousin. Okay. So within the degrees of consanguinity and affinity, we call it the bloodlines. You can't probably marry. You just discovered after that the person is your family. You can't marry the person. Or you can also discover that this person suffers from an incurable venereal disease, and the person knew of it, and the person never told you. So you can take steps to annul it. To annul those ones. But as for void, it is when the person is like the marriage never existed. And so, but if you only dissolve or you do a divorce of a valid marriage. So when the parties have actually been married validly, then in the event that they want to divorce, then they go to the court.
If you are listening to us, we've been talking about divorce. Remember, we started with the fact that the Bible says that God hates divorce. I don't want anybody listening to my program and saying that I'm giving the license for people to divorce. Please, no. God hates divorce. But sometimes, please tell them the phrase you used again. It's beyond
reconciliation.
Please listen. It's beyond reconciliation. Lawyer Vivian, somebody called me last week Thursday, and she was crying. And she said, Mama Rita, God bless you. And she was speaking Ga. Mama Rita, you mad a job. Mama Rita, you mad wono. You mad fable gojo. And I was wondering, eke program ne no fear ne program.
It's for knowledge.
So yes. I said, Ma ba mi no nu. Eke blanco mininte. Some marriage I went into. And the man kept beating me and beating me and beating me. And anytime we went to our family members, they'll say, oh, beating doesn't kill. Stay in. Let the man take care of you and take care of us. So she stayed in until family members actually realized that if they didn't come for her, this man was going to kill her. So she was telling me, if she knew the things I am teaching, she would have run with her children. And then she went again. So if you are just listening to us, I am not saying that divorce. Before you go through divorce, you should have spoken to your counselors. You should have spoken to your pastors. You should have spoken to, you should have spoken to people. All we are saying is that don't stay in and die. You realize that the thing is becoming abusive, verbal abusive, emotional, psychological, physical. And now the man is even threatening you. We are all here when we heard the case, and where did it happen? Is it Oklahoma? Where the man said to the brother-in-law, if I don't kill your sister, don't call me a man of God. Can you imagine? The man is sick. My darling, run for your life. The brother said, let me report. The sister said, oh no, don't do it. And that is what some women are doing. Oh, it will be okay. Please don't report. Please don't tell mommy about it. Please don't tell daddy about it. Please don't tell anybody about it. The next minute is all over the newspaper that somebody has killed it. So this is what we are talking about when it's beyond reconciliation. So if you are in a relationship like that, all we are saying is that seek help. Seek help. So if you just joined us, this is what we are talking about. But then if the relationship sometimes is nothing, sometimes it's something, somebody came to sit in front of me. Oh, my case is like the one that the two ladies spoke. I said, please. Your case is nowhere near this. Your case hasn't reached there. Your man is a nice man. He takes good care of you, takes good care of the children. The only thing, the man goes out and comes at 11. That's all. And the man is saying, I am working. So why do you think that I am going after other women? So please, I'm not saying divorce. You haven't reached there yet. Lawyer Vivian, what happens to the children?
The law
takes over the children?
The law makes provision for the care of the children. In fact, there's no divorce proceedings before the court that the court does not take care or make orders regarding the children. First of all, there are issues about who takes custody of the children. In Ghana, we have custody and access.
Custody and access. I like
so
that.
When one party is granted custody, the other person automatically gets access. Now, usually you will find when parties are, divorced, you will find that they tend to use the children as trump cards. So they pitch the children against the father, or they pitch the children against the mother, depending on who has custody. So the children will not want to see the other party, but it is their right. It's the right of the parties to take care of the children. And whoever has been granted custody by the court must allow access. And access is usually also within a certain reasonable limits. So the fact that you've been granted access by the court doesn't mean that you wake up Monday morning, you say, I want to see my children because I've been granted access.
1 a.m.
or 2 p.m. Or even when the children are in school, you want to see them because you say, I have been granted access, or I have access, or I have a right of access. No, it has to be within reasonable, so that you don't disrupt their schooling, you don't disrupt their time that they spend. Now, usually, and now I think the courts are shying away from that, because you find that sometimes some parties, in order to ensure that they get equal time to spend with the children, you find that parties will settle on a certain arrangement where maybe the custodial parent will keep the children during the week, take the children to school every day, and then pick them up all throughout the week. And then on Friday, the parent that has access will pick the child or the children from school and then present them back to school on Monday for the custodial parent. It's not a very effective arrangement.
That's right.
The reason is that usually the custodial parent will hardly have time to spend with the children during the week. And so it's not a reasonable custody or access regimen. You might want to look at it more like maybe spending or dividing vacations or maybe holidays, so that both of you can then spend quality time with the children instead of the weekly, bi-weekly sort of arrangements.
On what ground would the courts give custody to one party? What
there are
do they look at?
The factors that the courts will look at in the grant of, first of all, it will look at the ages of the children. In fact, one of the basic things that the court will take into consideration is the need of a young child to live with the mother. So you find that usually mothers are giving custody because a mother will naturally be able to nurture a child. And so when the children are very young, the likelihood of they being given to the mother in terms of custody is very high. But there are instances too where you can tell that it would not be in the best interest of the children
to
give them to the mother, especially if the mother is unwell or if the mother has been abusing or violating their rights or hurting them or doesn't know how to live with them. Then the court will look at the circumstances and then say that in the best interest of the children, I will give the custody to the man. But usually, depending on the ages, they would say they will give to the woman.
And then I also hear that in some instances, when the children are a bit old, they ask them, who do you want to live with?
If the children are at ages where they can express an opinion, it is not binding on the court. The court would ask them, you know, but we all know, and the judges are experienced enough to know that sometimes in the middle of divorces, both parties are trying to buy the love, if you like, of the children. So they would begin to give the children money, biscuits, candies, you know, toffees, things that will make the children think that if
this one loves me
if I stay with this one, I'll continue to get all these nice things. And so if you ask the child without necessarily applying the skills of a trained judge, you might end up thinking that, oh, the child says, I want to live with mommy. Maybe mommy is a better parent in terms of custody. But the judges have been trained, so they know the kind of questions that they would ask to elicit the information they need to know which of the parents to grant custody to and which to allow access. But it's almost automatic. Once the other parent has custody, the other one will automatically get access.
What happens to almighty property? Well, I know people are ready for that.
I know. So the default position is that properties that have been acquired during the marriage.
During the marriage,
yes, become jointly owned properties. The default position. I say default because it is not in every case. Now, this is the position that people don't understand. Some people think that, well, now they say it's 50-50. Once you are married to the person and you acquire property, then upon divorce, that property becomes automatically, it's not automatic. In fact, it is possible for you to be married and still distinctly own property quite separately from your spouse.
Wow.
Because it is a constitutional right. You can decide to own property by yourself or own it in association with others. So it is a constitutional right. But once you are married, the thinking is that you do things for your mutual benefit. And sometimes it is not necessarily a 50-50 sort of situation, but maybe a 70-30. maybe a court will look at the entire incidents to the marriage and decide that, well, looking at how these parties have operated, looking at how they have operated their marriage or managed their resources in the marriage, it is equitable to give 70% of the property to the woman and give 30% to the man, depending on how the properties were acquired. And you don't need to be to contribute cash. And that's the key thing that the law has determined now. You don't need to contribute cash to the acquisition of the property to be a joint owner.
Come again.
You don't need to contribute cash to the acquisition of a property to be a joint owner with your spouse. Mm-hmm. You don't need to. You may, but you don't need to.
Okay.
Contribution is not necessarily cash. Contribution will be looked at in different ways. How you manage the house. I mean, you were able to do things that allowed the other party the free will, the free hand, to be able to engage in productivity which, you know, was profitable enough for the person to get the money and acquire the property. Okay. So once the property had been acquired, using the efforts that, you know, because sometimes some families, they will say, oh, I'm trying to construct a property or something. Okay. And so you use your resources to manage the home, to maintain the home. Okay. That way, you don't give the person money, but it is your money which is holding the fort while the person now construct the house. And in those circumstances, when it is time for divorce, you can't say that the person does not have an interest in the property because the person didn't contribute cash to its acquisition. So the dynamics are there. The court will look at all kinds of things. It is not a one blanket fits all sorts of situation. It depends on the circumstances.
So where the woman was a homemaker, never worked, took care of the home, homework,
yes,
washing of dishes,
yes,
laying bed,
yes,
and the man says, the woman never helped me in anything. She never gave me a peswa. Why should I share 50-50? And we hear this all the time.
All the time, because the person is looking at contribution as cash. Okay. But I'm saying that the courts have moved away from that definition of contribution. Okay. They are looking at how the parties have, you know, lived their life, the incidents to their particular marriage, how they ran their lives, how they ran their marriage, how the other party was, if for example, that homemaker was not making the home, how this man probably would have to be home with the kids.
That's true.
And so would not be able to engage in the profitable business he is doing that would allow him, you know, to earn money to get the property. And so the court is always looking at those, they look at everything in totality. They won't just say, well, because you didn't give one CD, you are not entitled to it. No, that's not what the court does now.
We will take a commercial break. I hope you have your questions ready. People have had their questions ready in the past 2 weeks, in the past 3 weeks. Please, if your questions are ready, send it to us now. We will go on a commercial break, and we will come back to you with Ask Mama Rita.
Let's go!
My name is Mama Rita, the wife of the Apostle General Sam Kranchiankra. I come your way every Wednesday with Family Life Series. I also come with seasoned counselors to do question time with Mama Rita called Ask Mama Rita segment. where you can ask all your questions. Anything concerning your marriage, anything concerning your relationship, you can come and then ask, and we will answer you. Make a date with Mama Rita on Family Life Series. Family Life Series, building stable and happy homes.
Family Life Series with Mama Rita, showing this and every Wednesday at 7 p.m.
Welcome back to Family Life with Mama Rita. If you are just joining us, we are looking at divorce. Divorce. The Bible hates divorce, but sometimes, the legal term is when the marriage is beyond reasonable.
It's broken down.
It's broken down beyond
reconciliation.
When the marriage is broken down beyond reconciliation. When the marriage is broken down beyond reconciliation. I know somebody who is watching me now. In the past 7 years, they live in the same house. They've never talked.
I've done one with 17 years.
You've had one for 17 years?
I did one where the parties hadn't talked.
They live together. But in the past 7 years, they share different rooms. This one goes to the kitchen and cooks. When this one is done, this one goes and cooks. They cook in shifts for 7 years. So this is what we are looking at. But Lawyer Vivian, before we go to the questions, can kids be given to a third party?
Yes.
The kids are not given to daddy, they are not given to mommy, they are given to somebody else. On what grounds?
If it won't serve the best interest of the children,
okay,
to give them to either of the parties. So let's just assume that maybe the parties are drug addicts.
Okay.
It will not be in their interest to place them in the custody of either of the parents. And so it will be better to look for, in fact, the court will look for maybe a closer relative, maybe a grandmother or a grandparent or an uncle or an auntie of who is responsible and in whose custody the court feels the children will be safe.
Okay.
The court will grant custody to those children, to those people, but definitely not the parents who may be unfit.
There are no grandparents. What happens? Can they be given to, in the Western world, they are taken to foster homes, and they have foster parents and all that. I know we don't have anything like that in Ghana. What happens? I know, well, everybody says in Ghana, everybody has somebody. But assuming grandparents are dead, only children, what happens?
They will be taken to the social welfare department.
Social welfare department. Wow. Hey, co-hosts. I know there are lots and lots of questions.
Yes. We have interesting questions coming in.
Very interesting questions coming in.
Good evening once again. This is Chiwape Emmanuel, the special co-host. I was with Mama Rita at the United States. We are back. I was there in spirit, but physically you'll see me there soon. Reverend, you might know you are waiting for me.
Hey!
Yeah, we shall be there. All right. Mommy, today we are having a lot of legal innuendos and grammatical programs. This one
shouldn't ask me those questions when Lawyer Vivian is not here.
There are actually spillovers from last week on the breast cancer, but we'll find a way around those.
Wow.
This one says, good evening, Mommy.
Good evening.
Is it possible for a man to do traditional marriage with a woman? They have two children before he comes to marry another woman in church. How does one go and have the second one dissolved? So there's a traditional marriage.
Okay.
He goes ahead to have another marriage in church. So the question is, how do I go about to dissolve the second marriage? Since, according to you, that is the legal one.
The person has been married traditionally, and then with children, and then the man goes ahead
to marry another person,
the second one, and marries that person
Under part 3
under part 3.
of the marriage. Okay, the second marriage is void.
The second marriage is void.
It's void. Because so long as the first customary law marriage subsists, in the law, it is only that marriage that can be converted into a marriage under part 3.
Wow.
With that same person. So that is what conversion is. That's why it says that when you are coming to marry under part 3, you shouldn't have been married to somebody else, except you should be married to the same person that you are bringing to come and marry under part 3.
So it means that if you want to marry somebody else, then do the traditional.
Then it's traditional,
the
yes.
customary.
You can marry another person under custom, but you can't marry another person under part 3 of the Marriages Act. That second one will be null and void.
Wow.
So
Wow.
that has no legal consequences at all.
Wow.
No matter how big the wedding they hold, it still has no legal consequences.
And before the second question, I want you to go through the 6 factors again.
Okay.
And then with examples, so the ordinary person will understand.
All right. So the facts...
For divorce.
Yes. We say that there's only one ground for divorce.
Okay.
And that ground is that the marriage should have broken down beyond reconciliation.
I love that.
So that's the benchmark. The reconciliation is the benchmark.
So if it's not beyond.
If it's broken down but not beyond reconciliation, then it doesn't qualify for divorce.
Okay.
But that's it. It must have broken down beyond reconciliation.
reconciliation.
And the law says there are 6 facts
Okay.
that can be used to demonstrate that a marriage has broken down beyond reconciliation. The first one is adultery.
Okay.
And it's not just the fact of the commission of adultery, but that it must be that the other party cannot tolerate to live with the person who has committed the adultery because of the commission of the adultery. In other words,
So
if the party commits adultery and you get to know and you can forgive the person and you can tolerate living with the person, then
I like that.
you can continue the marriage.
Okay.
And so for that one, the law also allows, the law says, if in the spirit of reconciliation, I told you that reconciliation is the benchmark.
Okay.
If in the spirit of reconciliation, parties to a marriage in which adultery has occurred live together, even after the knowledge of the commission of the adultery comes to the other party, if they are able to live with each other in excess of 6 months, in excess of 6 months, then the law says then you can tolerate living with the person. And therefore, you can't come to court seeking the dissolution of that marriage on the basis of adultery. So the law always looks at the fact that it is not just, the commission of adultery, but you must find it intolerable. And in determining what is intolerable, the court says it is a subjective test. The question is, it is not whether you, a third party, somebody outside the marriage, a relative, a grandmother, or a counselor thinks that, oh, you can live with the person. No. It is the person against whom the adultery has been committed. Can this person, yes, if the person says, I cannot live with this party, it is that person's test, that person's answer to that question. That is what determines the tolerability. It is not about another person thinking, oh, you are doing what they have talked about it, forgive the person and continue the marriage. No. It is about that person. How does that person feel? And if that person says, I cannot tolerate, sometimes, anytime I look at his face or I look at her face, I imagine or I remember the adultery he or she has committed, and therefore I can't continue. It is very subjective. The second fact is what we call behavior, unreasonable behavior. We say that generally. It is not behavior which everybody says, oh, it's normal.
It's normal.
It is the effect of the behavior on the person complaining about it. So if the person says, well, maybe you are eating, and it is affecting me. Like maybe the way you eat your food, I don't like it, and it's affecting me negatively, and I've complained to you, and I've told you to change your way of eating, and you don't mind me. And it is something that I'm so particular about, and I'm complaining about it. then that one, they will say
It's
it's unreasonable behavior because it is affecting me adversely.
Okay.
Adversely. Usually you'll find maybe a couple are living together. The man wants to have 3 children.
Okay.
The woman says, I want to have 2.
2.
The man says, no, you must have 3. Otherwise, I'll go outside and go and have the 3rd one outside. And it's a big issue in the house. Some people will say, well, what's wrong with it? He's an only child. He wants to have many children. It is not. The court will look at the particular individuals to that marriage and say that, well, the test is subjective. But maybe if we look at the parties, we can understand why this man would want 3 children.
Okay.
We can also understand why this woman will want 2 children. But can the 2 of them, what is the effect of this insistence on having 3 children? What is that having on the health of this woman? And that is where the behavior, the unreasonableness of the behavior comes in. And even there, the court again says that if you are in the spirit of reconciliation, you are able to live with the person. Whatever behavior is being complained about, if the parties are able to live with each other after the commission of the last act, they live together in excess of 6 months, then you can live with the person. So every single time, the court makes provision for parties to be able to live together. Usually you'll find that when parties get married, especially in the first few years, when parties are getting to know each other and to settle with each other, some people are not very patient.
Wow.
So they would immediately, no, I don't want this. This is the behavior. They are beginning to know themselves. When they were courting, it was a touch and go sort of thing. They see each other maybe at church, and then they go their separate way. But when you come to live with the person,
that's when you know.
Then you begin to see that maybe the person doesn't like to bath, or the person doesn't clean the kitchen, or the person when the person is cooking, the person or the person talks too much. Or those are the things that you begin to. Those are things that under normal circumstances, it shouldn't be a problem. But if it gets to the point where the person...
It's a problem to you.
So that usually you say that some men will complain that women nag. Is nagging really by itself a problem? Generally, no. But there can be some nagging that will get so serious to an extent where it begins to affect the other party adversely. And that's where you have to watch it. Because then it becomes classified as unreasonable behavior, because it is the effect of the behavior on the other party.
We will take one question, and then we will come to the third, the fourth, the fifth, and the sixth.
Unreasonable behavior is getting interesting.
Hey.
Lawyer, you have to tell us. Guys who have been failing exams, since they married, they've not passed the single exams.
I see.
Is it unreasonable behavior?
Unreasonable.
I know one guy.
He failed all his exams.
Since he married, failed every one of them.
And who wants children who are shalai?
Very unreasonable behavior. All right, this one says, good evening.
Good evening.
My husband is divorcing because I have gotten to know the properties he has acquired. I wasn't in favor of the divorce procedure, but I have decided to agree after my legal advisor advised that I am entitled to a valuable part of it. I know, Mama Rita, that if I have to wait for a will, my name will not surface there. So I have decided to go for the divorce. Madam Vivian, what do you advise?
Well, I don't think I can say much about the divorce, because it's the man who is actually seeking the divorce. So he will go ahead anyway.
Because the woman got to know about the properties.
Once he, as for the reasons for divorce, if somebody wants to divorce, the person will find a reason.
The person will find a reason by all means.
As for divorce, I mean, it takes 2 to tango. And no court will tell the party, no, go and necessarily marry each other. They won't, there's nothing like that in the law. So I can't say much about whether his reason to divorce is good or bad. But I can say that if she's been with him during the acquisition of the properties,
that's right, the
court will look at the way they've run their marriage, and an equitable portion of it will be given her as property settlement between the parties. But I can't say for sure Whether it is a good decision or not, that's one I can't say. Just I don't have enough information in it to determine that. But I can say that she's entitled to a valuable portion, like she describes it.
So Lawyer Vivian, like you mentioned that if somebody wants to find grounds for divorce, they can go to all extent. What if this is not a justified grounds as far as the other party is concerned, but one person is pushing it? Would the courts necessarily have to grant it because it's just one person deciding to go for a divorce?
Most divorces, you don't have two people agreeing for the divorce. Otherwise, you don't have two people agreeing. One party will be the petitioner, the other one will be the respondent. And usually the petitioner or the party who initiates the divorce proceeding will be the one who will bring grounds or facts to demonstrate that the marriage has broken down beyond reconciliation. And so whether the other party, the respondent, likes it or not, if the petitioner is able to establish that the marriage has broken down beyond reconciliation, the court is likely to grant it. It's very rare for the court to exercise the discretion not to grant the divorce. It's very, very rare. The courts are cautious because what if what they are saying is actually true? And then you send the parties back to go and live together in harmony when there is actually no harmony. And all kinds of things will happen. Domestic abuse can happen. Domestic violence can take place. And the next thing you hear, somebody is hurt or killed. So the courts are very cautious of it. If the courts, usually what they will do, and the law allows the judges to do that, is when they see that there's maybe a little hope for the parties, they can send them to counselors, professional counselors, or ask them to go and explore reconciliation. That's why the benchmark is always beyond reconciliation, because you must even inform the court that you have taken steps to reconcile. There are some incidents that clearly the court will know that this one is beyond reconciliation, but naturally they will tell you, you know, you must do things, you know, try to explore settlement and reconciliation before.
So the unreasonable abuse,
behavior.
Unreasonable behavior, that's abuse.
It falls
emotional
perfectly.
Abuse, physical.
Perfectly. Because under the definition for unreasonable behavior, it's a component of action and omission. Like you can do something or decide not to do something. All of those things are behaviors that will have an adverse impact on the person complaining about. And that's where you have to look at it.
Lawyer Vivian, before the next question, I have a problem. Unreasonable behavior. Now you are saying that if I am slapped and I think I can take it, then it's fine. But here is the situation where maybe my next door neighbor, I can hear slaps all the time, screaming all the time. And I think that if I don't do anything about it, there'll be death or something. I approach my next door neighbor, the woman. She says, I'm fine. I can handle it. And you think that no. The way things, what can you do as an individual?
So this one is it falls within the Domestic Violence Act. So that one you will report to the police, the Domestic Violence Unit of the police, DOFSU, and they will take care of it. They will take care of it. You don't need to be the victim of a domestic abuse to be the one to lodge a complaint. It can be a neighbor. It can be a neighbor. It can be somebody. Sometimes people don't like to say these things because they are afraid of the consequences. Maybe they are financially dependent on the spouse, and so they are afraid of what the consequences might be if you take. And you know how our society, somebody takes this issue to the police and it's like, you've reported me to the police. I'm going to cease taking care of you. You want the police to jail me or the court to jail me.
Sometimes even family members.
And they do that a lot. You know, they do that a lot. But some of these issues must be sorted. It must be taken care of by the law, not necessarily family, but must be taken care of by the law. But your best bet is to go to the police and lodge the complaint,
so,
and then they will take.
I want us to establish this fact. We don't always need the victim
to report.
No. A family member can report, A neighbor can report.
Anybody
Who
gets
sees
to
it.
know.
Even
Yes.
children can report.
Yes.
Because sometimes children are living with their mothers.
Yes.
And they see daddy.
Usually they tell their teachers.
Okay.
You know,
But
some
unfortunately in Ghana, you know, in the Western world, if a child goes to school and tells the teacher can take up the case
call the
to
police,
social
yes.
welfare, call the police. But in Ghana, if a child goes to school and tells the teacher thinks that this is not my problem, this is not my business. Me ya wine and me nkoka, you know.
But
What
some teachers have done that.
Okay.
Some teachers even in Ghana have done that. They've taken up when they notice changes in the child or in the children. Sometimes the child is actually the victim.
Okay.
And they report these things to DOFSO, and they take steps. They know how to handle these things, and they take steps. We don't have, of course, unfortunately, we don't have a very elaborate system or a vigorous system which actually takes take the child out of that abusive environment. Because if the child is dependent on the person perpetrating the abuse, then there's a problem. If you take the child, where are you taking the child to?
Where are you taking?
You don't have the proper social structures that will absorb that child and take care of the child. But that still does not mean that if there's some abuse going on and it has come to your knowledge, that you shouldn't say that. You shouldn't report that. But these are things. I mean, if the child is a child to parties that are in court for divorce, these are things that the courts will look at. Because there's no divorce. If once there are children, the court must make orders in respect of those children. Orders regarding maintenance, orders regarding their schooling, who pays their school fees. And one of the other things that I need to say here is that when parties are divorcing, you know, they say that, you know, it's maybe the man who must pay the school fees. No. Maintenance of children is a joint responsibility. And usually it is the party who is better financially endowed that the court will make orders to take care of the children. Because once it has to do with the children, they are not looking at what you think or what you don't think. What is in the best interest of the child? And that the court will make orders regarding that. So it's not so much what the parties
So we will
think.
take a question and then we will go to point 3 and 4.
Thank you. Keep your questions coming through. +2 332 00 515253. Let's get engaged on social media platforms with the hashtag #AskMamaRita. Ask Mama Rita. Okay, we'll go straight to the next question. Mommy, this is an interesting one. It says, good evening, Mama Rita and Lawyer Vivian.
Good evening.
Before we got married, he was very committed in church activities. And this is one of the reasons why I got so interested in him. Can I go ahead and divorce him in court on the basis that after marriage, he is totally not interested in church anymore?
Wow. Very interesting question.
It can be subsumed under unreasonable behavior because of the effect it is having on you. Because remember, she says that it's one of the key factors that influence her saying yes.
To say yes and to go into the marriage.
So once that has changed, she is obviously disappointed. It is affecting her. And once she can demonstrate that this is affecting me and tells him that, look, you have changed. This is affecting me. Can you do something about it? If you fail to do something about it, then it becomes unreasonable behavior.
Let's go to point 3.
Point 3 is desertion.
So we can do point 3 and 4.
Yes, desertion. And I'm not going to, it's a bit technical, but I'm not going to be, I'm not going to go technical about it. But desertion is where one party just abandons the whole marriage thing and goes, whatever it is that pertains to the marriage, he stops doing it, or she stops doing it, and he's gone.
Left to the home.
Left the home. Not the physical living, but left. Sometimes you can have parties who are living under the same roof, but one party is guilty of desertion. It's a very technical thing.
You haven't slept with me for 2 years. Is it desertion?
It is not.
It's not.
It's not desertion. Because the person may not have slept with you for 2 years, but is performing other parts of the marriage issues. So maybe he's paying school fees, and that pertains to your marriage. He's taking care of the children. He's cooking, if that's what he was doing prior to the situation you find yourself in now. So it is very technical. Desertion is a bit difficult to prove, but it's total cessation of whatever it is that pertains. So you've carried out. Maybe even if you are living under the same roof, you've left in terms of you are doing nothing together. You are living your life as a single person when in fact you are married. So desertion is a bit technical, and it must exist for a continuous period of 2 years.
2 years
before you can present the petition for divorce. And then you have the fourth one.
So let me come to the desertion again. Assuming you were cooking for me, and for 2 years you haven't cooked.
It is not desertion.
It's not.
Yeah. It's not desertion.
Wow. So
that on itself is not desertion. You may be doing other things.
Other things.
Yes. Maybe you have stopped cooking, but you are washing. Or maybe you have stopped going out with him, but you are cooking for him. Or you are sleeping with him. So there's some things that you may have stopped. It doesn't necessarily mean you have deserted him. Desertion is a total cessation of all the things that pertain to the marriage. So usually when maybe somebody says, oh, he has stopped paying school fees of the children, he's deserted us. No, it's not desertion. Desertion is very technical. It has to be total cessation of everything relating to the marriage. But again, and it must exist for 2 years before a continuous period of 2 years. And then you have the fourth fact, which is that the parties have not lived together as man and wife for a continuous period of 2 years, but with the consent of the respondent for the grant of the dissolution of the marriage. I'm going to explain.
Wow, you haven't lived together.
As husband and wife.
3 and 4 is very different.
3 and 4 they are different. You can have the same state of definition for desertion exists as 4. But this time, the difference is that you must come to court, you the petitioner, who is claiming that the other party has not lived with you as husband and wife for 2 years. You must have his consent or her consent in writing to show that, yes, that the person agrees to the dissolution of the marriage. So that's the difference. But the definition of desertion is what must exist in terms of the separation or not having lived as husband and wife for a continuous period of 2 years.
2 years,
Then you can. Then you have the fifth fact, which is that you must not, or the parties must not have lived as husband and wife for a continuous period of 5 years. That one, you don't need the consent of 5 years is long enough.
It's long enough.
If the
so in other words, one party has left home.
Yes,
or you can even be together, but
they stopped. Nothing has happened. The two of you are not practicing marriage. Just everything has stopped for 5 years.
For 5 years.
And that one, the court, once you come to the court and you are able to establish to the court that the parties have not lived as husband and wife for 5 years, the court says that is enough proof that the marriage has broken down beyond reconciliation.
So the one that I know, that's 7 years. They are living together, separate bedrooms. They don't talk. This person doesn't cook for this one. This person goes, cooks his food. This person goes, cooks her food. That one is 5 years. It's beyond.
Yes. At least 5 years. Once you are able to satisfy the 5 years, the marriage has broken down beyond reconciliation.
Wow. Well, we'll take one question and then we'll come to the second one.
All right, this question says, good evening, Mom.
Good evening.
I was just in a relationship and we had a child. He wants to take custody of the child, to which I disagree. Mom, we've been to DAFSU on several occasions over this same issue. And now I have decided to take full custody of the child without taking anything from him. But my parents suggest it's a cheat because he one day may come claiming for the child. The child has been with me for some months now. He hasn't sent any maintenance fees whatsoever. What should I do on this occasion? Please advise.
Vivian, and we have this all the time.
Yeah, I think they should go to, she should go to court.
She should go to court.
Yes. Now, she has the physical custody of the child. But she should go to court and get a court order, which will ratify the custody for her. And then she can actually ask the court to let the other parent contribute to the maintenance of the child. And that will come in the form of an order of the court, where if the person does not comply with you can, what we call levy execution. You can go to court, they can attach his property, maybe a car, a property, a landed property that he has. They will levy it, they will sell it, and then they will use it to take care of the child. Okay. So you can go to court. In fact, it's better for the person, once they are not married, it's better for her to go to court and get a court order in respect of the custody, and then looking at the age of the child, it's likely that the custody will be granted to her.
Because we have this.
It's very common.
It's very, very common now. And the annoying part, if the child is a lady, it's time to get married, and then the man shows up, and they are the ones who give a long list. I want a goat. I want a cow.
I know.
You must buy me a laptop.
An iPhone.
An iPhone. I mean, so it means that the women must wake up and take the men to court.
For maintenance. You know, there's a culture here that if a woman takes you to court, then you know, it's like a taboo subject. You don't take me to court. Then you want the court. What do you want the court to do for me? You know, that kind of thing. But it is the law. Okay. Maintenance is joint, and sometimes caring for children is not necessarily the money that you give, but even, you know, the nurturing of the child, the orientation of the child, the teaching of the child of the ways of, you know, even bringing the children to church. All of those things are things that actually mold the lives of the children. And so if you can't say, for example, that because I didn't marry you, if we have a child, I won't take care of the child. I've heard stories where the man will say, I've gifted the child to you. I've given it to you.
I've given it to you.
It's a gift.
And unfortunately for us as born again, the Bible teaches us forgiveness.
Yes.
Now, the child grows up, the child is doing very well, and because of forgiveness, she's bound or he's bound to forgive the father and take care of the child. The Bible says, honor thy father and thy mother. Meanwhile, you were never there as a father. Oh my God.
Some of them don't always get it that way. Okay. Maybe if the person encountered a father figure who played a more crucial role in that person's life, that person is the father. I mean, the father is not necessarily the person who gave birth to you.
Lawyer Vivian, we have issues in this church where the father never showed up in the life of the lady. Now it's time to marry. And the father comes and says that, I am the father. By law, I am the father. We've had cases in this church where engagement, where you have to give something to the father-in-law. You are giving to 2 fathers and you are giving to 3 fathers. The biological father who never took care of you.
I think it's the woman and the child who have to indicate who the father is.
Okay.
And it doesn't have to be the natural father.
It doesn't.
It's the person who actually was the father.
Okay.
Who played the role of the father in the child's life. That is important.
I like that.
There are a lot of people who are encouraged by that kind of thing because they think that whatever happens, well, the child will come back to me.
The child will come back to me.
They always say that, especially when it has to do with occasions like marriage, the child will come, the person will redirect. But, you know, people have to be taught that responsibility is your responsibility.
That's right.
And if you're actually living after God, God is responsible. God takes care of his own.
That's right.
So you can't say that you are a father when in actual fact you never played a role. You've
never been there.
There are people, I mean, fatherhood is not...
Well, we'll take another question and then we'll come to point 6.
Yes, Mommy. I think this one borders on the issue of misbehavior. Says, Mommy, my question is, my husband likes to suck my breast too much.
Hey.
I hope this is not going to be a problem. It sounds like a question for last week on breast cancer.
Oh, but we were told that if they suck your breast, then you never get cancer.
I thought this was unreasonable behavior.
Please, this is not unreasonable behavior.
But she says too much.
Too much.
Morning, afternoon, evening.
Oh, Samara. So this is unreasonable. Please, it's not. I hear when they suck your breast, you will never get cancer. This one is not from me. It's from the two doctors who were here last week. So please, we can move to the next, and then we come to the sixth point.
Please, my husband has married another woman, even though we married in church. And since March this year, all he does in our home is to buy gas and prepaid credits. I am working and taking care of the children, food, diapers, clothing, and everything else. If I ask him for money, he says if I can take care of the children, I should leave because that is what he actually wants.
If he can't take care of the children, or if she can take care of the children?
If she can.
Okay.
Oh, sorry. If she can't take care of the children, she can leave because that's what he actually wants. Our sex life is nothing to talk about. What should I do?
Hey.
What does she want?
I like that. I like that.
That's the whole. What does she want? Because at this point, first of all, the second marriage is. I'm assuming that when she says church marriage, it is marriage under Part 3 of the Marriages Act, which is monogamous. Okay. And so the man is not allowed under the law to contract another marriage, whilst her marriage to him is in existence. So that marriage is of no legal consequence. But it also doesn't change the fact that he is not being responsible towards her and their children. And so she would have to take steps. Maybe if she doesn't want divorce, it is not only in the circumstances of divorce that you can go to court and ask for or make an application or petition for maintenance.
Okay.
It is not only in the context of divorce. You can actually petition the court for non-maintenance. So where the person who has responsibility towards you or has responsibility towards the children neglects his responsibility or neglects her responsibility, even though the person has the wherewithal, the person has money, the person is working, the person is earning money, yet the person decides that I'm not going to apply that money to take care of my wife or my children, who are my responsibility. Then you can actually make an application to the court.
To the court?
Yes.
You know, in Ghana, once you go to court, then you must be ready for divorce.
Not necessarily.
The man will say, because you took me to the courts.
You can also petition for non-maintenance. You can petition for non-maintenance. And the court will look at the circumstances, and the court will make orders.
Okay.
The court will make orders for maintenance.
Let's look at the last one.
So the last one is like a general thing. It's actually a very unique fact for us, Ghana, because in other jurisdictions they only have the 5 facts.
Okay.
But we have the 6th fact, which says that where the parties have, by their diligent effort, been unable to settle their differences, whatever the differences are. Sometimes the issues are plenty. The differences are maybe differences that they cannot really tell, but it's just
there's always a quarrel.
There's something.
Always an argument. Yes. Always a fight.
You can subsume that under fact 6, that the parties are unable to reconcile their differences.
Wow.
And so it would go to show that the marriage has broken down beyond reconciliation.
Wow. Can we have another question?
This one says, hello, mommy. Please, if you get married in Ghana and you want to join your husband in the UK, does the UK recognize the marriage that was done in Ghana, or do you have to marry under UK again?
Okay, so I'm thinking that when she talks about marriage in Ghana, I'm thinking she's talking about the customary law marriage, which is largely undocumented.
Okay.
And so you would have parties who are actually trying to migrate to other jurisdictions because there's no proof of it, there's no certificate, But here, the law also allows you to register your customary law marriages.
Okay.
So you can register that to show.
To show that I'm married.
And fortunately, there's no time limit for the registration of customary law marriage, except that, of course, it must be done within a reasonable time after the celebration of the marriage. But there's no time limit, unlike the Mohammedan law marriage, where it says that it must be registered within a week, or otherwise it's not valid. But in customary law marriages, there's nothing like that. So you can register that and still get a document to show.
Okay.
But if you don't have that, and you haven't registered the customary law marriage, there's still you can make a statutory declaration to show, supported by an affidavit of maybe your head of family or the members of your family who were present at the celebration to show or demonstrate that you have actually undergone customary law marriage with maybe Mr. A,
Okay.
who probably wants you to come over
Okay.
in show of or in proof of the marriage.
And if it's part 3?
If it is part 3, there's always a divorce marriage certificate.
Okay.
So that one, once you have the marriage certificate, it is proof that you've actually contracted a marriage under part 3. And marriages contracted under part 3 is synonymous to the marriages contracted in the UK,
Okay.
which is the monogamous marriage.
Okay.
They don't have customary law marriage. It doesn't mean that they cannot recognize customary law marriages. It's just that they don't have it.
Okay.
And if you were marrying there, they would expect you to contract a marriage under their law, which is
Okay.
a monogamous marriage.
Okay.
But if you are here and you are married under custom, it doesn't mean that you are not married to the person. It's just that they need to see proof that you are indeed married. Just because some people will just carry people and say, "We are married under custom with this person," but they need to see evidence of that marriage, and that's all they are interested in.
Okay. Somebody asked me a question. Can an aggrieved family member go to court to contest a will?
Yes. If the person is a beneficiary
Okay.
of the will,
Okay.
and the will has not or does not satisfy the form in which wills should take.
Okay.
Because under our law, when a person makes a will, there must be 2 attesting witnesses
Okay.
who must be present when the testator or the person who made the will was executing the will. And they must be present at the same time when the person is signing.
Okay.
You are not, the witnesses are not attesting to the contents of the will, but they are attesting to the fact that the person who made the will signed the will in their presence.
Okay.
Now, if you don't have 2 attesting witnesses and you have only 1 attesting witness, that will is invalid.
Okay.
And so you
Wow.
Yes, it's not valid.
I don't
Maybe
think people
one day,
know
one
this.
day,
One day
Pastor
we'll talk
Jifa
about
would
yeah.
come and talk about wills. But that is what it is.
Okay.
It's that serious. And you know that wills only take effect after the death of the person.
yeah.
So it's important that, it's when you are doing a will, you do it properly.
Okay.
And so if there's anything about, you can contest the will.
Okay.
If, for example, you are a spouse
Yeah.
and you are a dependent of the person, your husband.
Okay.
I'm just going to use the example. Usually that's what the example we use, the man and the woman.
Okay.
And your spouse did not leave a reasonable portion of the estate, his estate for you.
Okay.
You can contest it. If you are a dependent, you can contest it.
Okay.
He may have given it to his children
It's his children.
or his relatives, but if he doesn't leave a reasonable portion for you and you are a dependent, you can contest the will.
You can contest
and
the
the court is one of the only ways where the court you will see a court actually take steps to try and vary the disposition in a will.
Okay.
Otherwise, it is what the person has written
okay.
that will be respected. But it's one of those ways those allow a child who is dependent on the testator.
Okay.
If the testator doesn't make provision for that child can actually go to court and have the will varied so that provision will be made for that child's maintenance or care.
So for assuming a 25-year-old child.
If you are 25, you are not a child.
You are not a child. Oh, but can that?
There are circumstances.
Okay.
When we talk about a child and maintenance, you may have a child, but you may have a child who's gone beyond, who has attained majority, we say, maybe more than 18 years.
Okay.
But the person is still in school.
Okay.
And is being taken care of.
Okay.
So there's that responsibility of continuation.
Okay.
Otherwise, if, for example, the person has gone to school, the person maybe became 18 years at level 100 of the university, and then you say, well, because you are now 18, I'm not taking care of you. The law says I should take care of you until you attain majority. Now you are old, you are 18. How is the person going to go to when the person is reliant on you for the fees? And so that one, the law would expect you to continue.
Why I'm saying that is, assuming the man has 4 children, the man divorced their mother, remarried, and then in the will, everything went to the stepmother, but the children are old, 18 years and above. They are out of school. Can they go and say no?
No, they can't.
They can't.
No, they
No,
can't.
but assuming they think that
They
there's
can't.
something, I mean, the stepmother did something.
They can't. In fact, spiritual things, we can't bring those
No,
things.
not
in the-
spiritual.
They can't.
Physically.
They can't. Unless their claim is to, say, for example, the first wife, unless her claim is for joint ownership of the properties that were acquired. Let's say when he was living with her, they acquired properties jointly, or they acquired property during the pendency of them, she can stake a claim in those properties. Then she can say that I am staking my claim, my interest in that property, by virtue of the fact that I was around and I contributed to the acquisition of that property. But she can't come back and say that...
Not the wife, the children.
The wife. The wife can come and make a claim.
The wife can come
Yes, and make a claim.
Wow.
That these are, I mean, I contributed to the acquisition. This, when it has to do with divorce, for example, the distribution of property is not between the parties and their children.
Okay.
Even though a court can look at the circumstances and decide that I am making an order so that the proceeds of a particular property which belongs to the parties are committed to their care. But it is not, the distribution is not between the parties and their children. The distribution of the property is between the parties themselves. So that you can't say that, well, some people, in order to avoid or to try to take the properties from the reach of the court for the purposes of distribution, will say that, well, I have put the property in, I've committed the property, I've put the property in the names of our children.
Okay.
So that he's trying to avoid the court saying, well, property A and B should go to the woman. So he says, well, they are all for our children.
Okay.
No.
Okay.
You can't say that. The right to property is between the spouses.
Okay.
The spouses, even though the court, looking at the circumstance, can say, well, maybe this is a commercial property, and because the children are still in school, the proceeds of this property should be used to take care of their fees or whatever, or to maintain them until they attain or until they complete the school. And then it reverts to the parties jointly.
Okay.
But it's not between. Some people try to hide property by saying that, oh, well, now somebody, you are giving it to these people, the children. That's not it.
Well, it appears discussions on wills and it's going to be another series of its own. This one says, hello, Reverend Mama Rita.
I like that title.
Then the trouble continues.
Reverend Mama Rita.
Reverend Mama Rita.
Then I can imagine
the weight of the issue coming.
Yeah.
Says, my wife has called for divorce because of financial problems. Her family is fully in support of her. I am really confused as to what to do next. Please advise.
Hey, lawyer, this one is not me.
So
the woman wants a divorce
because the man doesn't have money.
Yeah.
So perhaps it's not because he doesn't have money,
yeah,
but because of what that is doing to her.
Right.
Maybe she's suffering. Maybe she's unable to do what she wants to do because the man doesn't have money. But the question again, is not just a very simple, I don't have enough information, but it's not just a simple conclusion that, well, he hasn't got money, so she's divorcing him. What are there are, with such issues, there are bound to be many more issues that are undercurrent, you know. What is he doing? Has he just lost his job?
That's right.
If he has lost his job, is she in a position to help him? Because it is also possible for a spouse to go to court and and tell the court that, well, I have lost my job, and I want my wife to support me, and she is failing to do so.
Wow.
Those are the circumstances that a court will look at it. I mean, a man can go to court, and even though culturally, you know, they say that men
take care of women.
Yes, men take care of women, but under the law, the word there used is gender neutral. It is spouse. So either of the spouse can actually go and ask that, well, I've recently lost my job, but you are working. You have the financial wherewithal, and so the court should make an order for you to maintain me until I can get back on my feet again. So again, we have to look at and investigate what is the nature of his. Is it a temporary thing, or is it something that he doesn't like to work?
Okay.
And so he's
That's
not earning
right. That's
money.
right.
And so if that is the case, then the issue is perhaps you are the one rather committing that unreasonable behavior,
Okay.
because you have refused to look for
To
a job.
work.
You
Okay.
refused to work, and so you are unable to assist her
Okay.
or contribute to the running of the home.
Okay.
Maybe she has several other
I like
financial responsibility, and you are not helping. And maybe you are home and rather criticizing her. All
Yeah,
kinds of things can
yeah,
come into
yeah.
play. So I'm not answering your
That's
question
right.
directly, because I don't have the full facts.
yeah.
But if it is a temporary thing,
Okay.
then we would expect naturally that she would
Okay.
assist you
Yeah.
if she is working and she has the financial resources. If she also is also not working, then you can understand that there will be a lot of problems.
That's
I mean,
right.
if she is not working and
That's
you are also
right.
not working,
That's right.
how are you able to live? You know. So
It
that's-
could also be that he's not working, the lady is the one working and supporting the home.
yes.
Yet you don't do anything in the house. You don't help with the children. You don't help in taking care of the homework of the children. You don't help in cooking. You don't help nothing.
It's very likely.
The woman will have to wake up, bathe the children, get them ready for school. She will be the one to drive the children to school, drive them back. She will be the one to come home and is the one cooking. She's the one doing anything. So what's the use? What's your use in the house?
It's very, you know, even though the law says either of the spouses can actually come and ask for
Divorce.
maintenance
Maintenance,
from
okay.
the other party, if the other party is the one who has the money. If a man comes to come and ask for financial assistance from the woman, the court will look deeper into the situation. The court will ask certain questions.
Okay.
Why is it that you, the man,
Yeah.
because culturally,
Culturally.
you are the one supposed to be. So the court will ask questions. Why are you asking her to assist you or to maintain you? What has happened to you? Were you working before? What happened to the job that you were doing? What if it is seen that you're not working, and then you were actually even dissipating the little resources that she brings home? Then you're not likely to be given, you know, orders of support.
So,
I like to have, you know, further
That's right.
details
That's
or
right.
information on
That's
his
right.
circumstances,
That's right.
but just the information he gave is
Yeah.
not enough for me to just.
so this is not to just the man who asked the question, but to all men. I know Ghanaian women are very reasonable women. Very, very. So, yes, when I married you, you were working. Now you are not working. I won't divorce you because you are not working. My darling, this is to all men. I won't divorce you because you are not working. But I will divorce you because you have become useless in my life. You are not working. You are not working. I have cooked soup, cooked stews, and it's in the freezer. During the week, when I go to work, you expect me to come back from work and cook yam, and cook rice, and cook. And these things are coming up all the time. You are complaining that I'm not tidying up the house. Meanwhile, I go to work, come back, and you are sleeping. My darling, these are things we need to look at these days. If I am the one working, yes, I expect you to also meet me halfway. By the time I go bring in the money as the woman, you too, prepare something small. Let me eat. By the time I come home, just like I would do for you when I am the one in the house, by the time I come home, you should do hot water, put my feet in, and juju ma akuma. I mean, so you see, I think that now Ghanaian men would have to learn. I mean, there's nothing wrong with it if it's the woman bringing the income and you are the one taking care of the home. We've spoken about this thing, you know, several times. I mean, we've said it. Please, there's nothing wrong with it. This one doesn't make you a man, woman, or a woman, man.
Less of a man.
Less of a man. You know, at the time I was working and my husband was on full time. During the week, he would be the one to bathe the children, get them ready for school. He would be the one to supervise their homework. He would be the one to prepare lunch. And then I come home sometimes on his way to pick up the children from school. He will prepare lunch, put it in a basket, put a napkin on it, and bring it to me in the office. And all my colleagues in the office knew that by between 12 and 1, my husband will pass by and bring me lunch. I mean, I also worked without complaining. I will work and carry. I mean, like there was something wrong with my mind. I will work and carry the money to him. Though the money was going into my salary account, I would always ask permission from him, you know, before I took something out of my account. Why? Because I knew he was playing his role. But you can't sleep 24 hours, and I'm the one who would have to cook, who would have to wash, who would have to tidy up, who would have to pay utility bills, and then, oh my God. My last question, and then we'll be done. After how long, Lawyer Vivian, in marriage, can you seek a divorce?
Ordinarily, 2 years.
2 years. Okay.
Ordinarily, the law thinks that 2 years is long enough for the parties, people who have been freshly married, to get to know each other,
okay,
to try to settle down,
okay,
so that ordinarily 2 years.
Okay.
But it is not to say that the law actually shuts the door completely.
Completely.
Because
okay,
sometimes there are circumstances where parties to a very fresh marriage will encounter certain difficulties which are very serious, such that you know that straight away this one, the marriage must come to an end. Wow. So the law says, unless you can show that the you as a petitioner, you are suffering substantial hardship, not something. Hardship must be not fleeting, not something small.
Something small. Then after 1 week, you say you want divorce.
No. The law recognizes that you will encounter, because you are getting to know each other.
Wow.
So it must be substantial hardship.
Okay.
It uses those words, substantial hardship, not just, you know, maybe one day you don't have money to buy something, then you say it's substantial. That's not the kind of hardship the law is talking about. Then, if you can also show that the other party, the respondent, is depraved, or there's depravity on his part or her part.
Okay.
So usually the depravity has sexual connotation. So the person wants maybe some weird sexual act, which you don't think that can continue. You can't continue. Okay. So that one, you can't. There have been instances where I've handled issues where the party says, well, can you invite your friend for us to have a threesome?
Wow.
You know, and this happens very early. Those are depravities. You know, you can't continue this. So the law allows you, even though your marriage is not 2 years, to come to present your petition for the dissolution of the marriage.
Wow. Hey, I feel like not ending, but we have to end by all means. Hey, we'll have to have Lawyer Vivian here again. But I want to say a very big thank you to Lawyer Vivian. I mean, anytime she comes, my audience love her. I mean, they love her. As for legal issues, we can't stop talking about legal issue. And for you who is listening and watching us, thank you so much. God bless you. I will come your way again, same time, same day, next week. I don't know if we'll be closing down on the divorce issue next week. I don't know. But I promised you, we're also going to look at things that you must do that you won't even come to the crossroad of divorce. I mean, there are things that you have to do that you won't even want to divorce in the first place. I've been married for 34 years, and trust me, I don't want to have a divorce. I'm not divorcing today, I'm not divorcing tomorrow. Even if I get to heaven, If there's anything like marriage in heaven, I will marry my husband again. Lawyer Vivian, thank you so much. I don't know if you have closing remarks, parting remarks to give to your audience.
I think that, like I said the last time, do unto others what you wish the other party to do unto you. That, for me, is really what will actually keep the two of you together. If you don't want the party treating you badly, don't treat the party badly. If it goes for both parties, behaving that way, I think the marriage will last.
Thank you and have a good night. I will come your way same time, same day next week. God bless you and I love you.